panelists. Did you want the state's attorney up now?
Yes.
Okay, Mr. State's Attorney?
Yes.
I didn't have indications here. Okay. You have everyone on your panel?
I'm right.
Okay, and we will have further panels after this. So this is everyone on the sponsor panel?
Yes.
Okay. Delegate Addison, whenever you're ready, make it.
By prohibiting out the involvement of law enforcement with the state's attorney. Out the involvement of law enforcement with the state's attorney. This helps ensure decisions are made using probable cause for an arrest warrant and include
Prosecutorial.
oversight by strengthening due process and
Prosecutorial
protecting
oversight.
the integrity of our justice system.
You know, I knew the word.
Commissioners may issue an arrest warrant solely off the basis of the private statement of facts or affidavit without reviewing significant evidence.
That's what happened to me,
House Bill
y'all.
336 aims to close marginalized gap by ensuring that the right not be given from allegations alone, but in the in-depth assessment of probable cause. The bill aims to strike and tighten the penalties resulting from knowingly reporting false statements to government officials and or authorities. The penalties can range from 6 months up to 1 year of imprisonment as a result of committing these false statements. False reports can have serious unwanted consequences for the defending party, law enforcement, and can contribute to the erroneous of trust. Strengthening consequences for intentional deception can be a deterrent, that will support both public safety and accountability within our justice process. I want to emphasize and note that House Bill 336 is not limiting justice for victims, but rather ensures that the powerful tool of arrest warrants are used fairly, reliably, and are consistent. Civil liberties and constitution must come first, even with active service for public safety. I personally witnessed the negative influence false statements can have, and I know many individuals share that experience. For this reason, I respectfully ask the committee to give House Bill 336 a favorable report. Thank you for your time and your consideration. I also would like to know that the government over there, did a report through the banner, which talks about how the mayor, child care providers, and others like D.A. Hawkinson, just the name of few who have been falsely accused. So I thank you for your time.
Thank you.
Yes. Good afternoon, Madam Chair, Madam Vice Chair, and distinguished members of the House Judiciary. My name is Ivan Bates, and I have the unique pleasure and opportunity to serve the citizens of Baltimore City as the state's attorney for Baltimore City. Let me first think that this is unique in the sense that you have the public defender's office and the state's attorney's office standing side by side supporting the same bill, which is we don't always see. But, I only have a couple minutes, so let me go ahead and focus on that. House Bill 336 will fix an issue that has long been a nightmare for the criminal justice system. Civilian review case enable an average citizen to take their complaints against someone to a court commissioner, often without any real evidence, and can have summons or even arrest warrant issued on that individual. Madam Chair, I can go down to the commissioner's office right now, swear out charges that you beat me up, threatened me with a firearm, and I fear for my safety. Yeah. And they will likely issue a warrant for your arrest, and your freedom. But we have found that many individuals have used this lawful tool as a way of retribution unlawfully against those they have a beef with. This year we tried streamlining the process to fixing this bill as simple as possible. Currently, there is case law in the course of judicial proceedings, statute under 2-608, which states that anyone who tries to square out charges against law enforcement officer, emergency service personnel, or an educator for an offense allegedly committed during in the course of executing their duties, would have the district court commissioner first send a complaint to the state's attorney's office for review. We would investigate the circumstances, send it back to the court commissioner with our recommendations, including whether a warrant or summons should be issued. We're proposing that we keep that same language, which for charges filed under 2-607, keeping in line with the current statute, ensuring that those entrusted to prosecute these cases first have an opportunity to review and investigate them before any actions be taken, such as issuing arrest warrants for an individual who may very well be innocent of alleged crime and not have a clue as to who the person is filing the charges. We've seen that in Baltimore City, the case of the rapper T.I., who my office had to intervene and quash a warrant placed on him by an individual unknown to him who was from Baltimore. Now, we've also recommended the state's attorney's office would have 72 hours to send any case involving domestic violence to those eligible for relief in accordance with 4-504.1, the family law article, back to the commissioner with recommendation. I'd also like to say I've spoken with a number of the advocates. We are very open to any amendments as relates to the time frame of that exception. The 1-year criminal penalty we have attached to this bill, and any other discussions around the language of this bill. I believe that with this new language, we satisfy everyone involved. We get to a system that works for everyone. Nothing in life or the criminal justice system is perfect, but this change in law would make a very seriously misguided process more manageable to all that are involved. Thank you for this opportunity to speak today, and I urge a favorable vote on House Bill 336, and I'm open to any questions.
Thank you, and whoever's going next, just state your name so I can get that information.
My name is Lupe Hawkins. I'm a resident of PG County, Maryland. I am writing in support of the criminal procedure district court commissioner and false statements. I have testified before this body for the past 2 years to prevent others from going through the same nightmare that I lived through. For several years, I was a victim of someone using the judicial system as a weapon to deliberately cause harm to myself and my family out of spite and pure hatred. In 2012, a very dishonest woman decided to make a false report against me. And without any investigation, I was arrested and placed in jail. This is where this long, horrific nightmare began. For 5 long years, I was charged more than 22 times based on a false accusation made maliciously by the same woman. By the 2nd year, it was verified in court that she had lied to the state and to the House of Ruth. In fact, the House of Ruth advocate, which was her attorney, filed a writ to withdraw representation because she admitted to them that she had lied and made this entire story up. Instead of the charges against me being dropped, the judge sealed the documents and sent my case to a full jury trial, allowing her to testify against me despite knowing that she was lying and not credible. That decision empowered her. For the next several years, this woman continued to make malicious false accusations. Not once was she charged with making a false report or committing perjury. After nearly 5 years, more than 22 charges, multiple speedy trials, jury trials, home confinement, and worse, jail, I was finally exonerated of all charges. She was eventually convicted, but not for any false statements she made against me. She was convicted of attempting to murder me in front of my mom's home. Today, I call myself a survivor. My family and I have made it our mission to help humanize those going through similar situations. It should never be that easy to destroy someone's life maliciously with no fear of accountability. We are simply asking for stronger screening and real accountability.
Thank you. I'm sorry to interrupt. Did you just finish that sentence for me?
Okay, just making false accusations is a crime and should be treated.
Thank you.
Yes. Amen.
Yeah. That's me.
My name is Beatrice O'Connor. I'm a Montgomery County resident, a longtime business owner, and today I'm here as someone whose family was deeply harmed by a system that lacks basic safeguards. For nearly 2 years, my fiance's ex-partner repeatedly made false sworn statements to district court commissioners. Each time a warrant was automatically issued without corroborating evidence or meaningful review. Because a warrant alone is enough to trigger a parole violation, my fiance's parole was violated the moment those warrants were issued, even though those allegations were later dismissed. As a result, he was incarcerated twice, first for 3 months, then again for 6 months, missing the birth of our son, for charges that were ultimately found to be fabricated and baseless. 7 criminal charges were filed in total for 2 years. Every single one was null pros by the state's attorney after evidence directly contradicted the claims. Yet despite that outcome, the consequences to his freedom had already occurred. There is no remedy for time wrongfully taken. The same individual has made approximately 20 fabricated civil complaints over the course of 4 years, all resulting in warrants or share of service. Not once was she flagged, not once accountability applied. This is not an isolated problem. Studies and court data consistently show that civil complaints are especially vulnerable to misuse, particularly in high conflict personal relationships. A significant portion are later dismissed or found to be unfounded. Yet arrests and moral consequences still occur first, because Maryland currently allows warrants to issue based solely on sworn statements without evidentiary checks. Our family has spent tens of thousands of dollars on legal fees, defending against allegations that should have never progressed. But the financial burden pales in comparison to the emotional toll. The fear, the instability, and loss of trust in a system meant to protect, not punish innocent people. My fiance committed a nonviolent bank offense in 2010 and unfortunately served 11 years. He served his time and rebuilt his life as a contributing member of society and a business owner, but under the current system, his parole status makes him uniquely vulnerable. This is not injustice. This is punishment without conviction.
Thank you.
Madam Chair and members of
I
the
need
committee,
to
good
speak.
afternoon. My name is Tiffany Hawley. I am a district court supervisor with the Maryland Office of the Public Defender here in this very county. I appreciate the opportunity to testify in support, along with the state's attorney's office, of Bill 336. For many of the past 13 years, I have worked on the front lines of Maryland's district court system. In that time, I have represented thousands of Marylanders, many of them among our most vulnerable, who have been pulled into the criminal legal system through Maryland's commissioner charging system. This process allows an opening for the criminal weaponization of our system, where the threat of arrest and prosecution is used not to protect public safety, but no, to gain leverage in personal disputes, custody battles, housing conflicts, and intimate partner dynamics. At its core, this issue is about due process. The decision to charge and arrest someone is one of the most powerful actions that the state can take against an individual. It results in pretrial detention, loss of employment, housing instability, and lasting damage to a person's reputation and family life. In most jurisdictions, that decision is properly structured through trained professionals, prosecutors, and law enforcement officers who are bound by ethical rules, legal standards, and constitutional obligations. House Bill 336 restores balance. It reinforces the principle that issuing arrest warrants for criminal charges should be reserved for those with particularized training for making that determination. I have personally seen how this system can be weaponized in moments of conflict, particularly in domestic or interpersonal disputes. In some of the most troubling cases, individuals seeking charges and warrants for arrest are not the persons who need protection, but rather people engaged in the harmful or violent conduct. It gives them the ability to initiate criminal charges and use it as a tool of leverage to control, intimidate, and silence other people through the threat of arrest, court involvement, and the lasting stigma of a criminal case. Moreover, more often than not, these cases are never prosecuted by prosecutors at trial. The damage of arrest and incarceration has already been done and can't be undone. This bill will fix that. I respectfully urge the committee to give House Bill 336 a favorable report. Thank you.
Thank you. Sorry. Are you testifying?
No,
Okay,
me.
all right. Are you here to answer questions?
Yes, to assist, yeah.
Okay, and your name?
My name is Justin Dickman.
Okay, thank you. Are there any questions, members? I see Delegate Conway first, and then I'll keep going around. Delegate Conway.
Chair, thank you, Delegate, for bringing this bill. Thank you, panel, for coming in to testify to the state's attorney in reference to an intimate partner situation. What's the difference between a warrant being issued and a summons being issued in the case of the ex parte?
I have Mr. Dickman from our office, he's the head of my juvenile division, so I'll go ahead and allow him to answer that.
Good morning. So your question is how, a difference between a warrant versus a summons?
Well, in the case of an intimate partner situation, that term was used, so in case of an intimate partner situation, what's the difference between a warrant being issued and a summons being issued, dealing with ex parte?
Yes, so a warrant being summoned, so an individual can go to the commissioner's office and file charges based off a statement of probable cause. Based off what is in the statement of probable cause, the commissioner will make a determination whether to issue charges first and foremost, and then from there, there's a second decision the commissioner makes. One is to issue a warrant in which the police or sheriffs go and arrest an individual, or they can file for a summons, in which only a letter or mailing will go out to the defendant, and then that would notify the defendant to come into court. All of that is done in an ex parte manner because the defendant is unaware of the individual taking out the charges at the time.
When the ex parte is granted, isn't law enforcement called to give the person the ex parte and remove them properly?
So that would be a civil matter where there's a protective order being filed. I just want to make sure I'm discussing the same
We were talking about an intimate partner situation. So in a warrant, I'm trying to figure out what's the difference between the warrant being issued and the summons being issued. But I know if it's a summons being issued.
He ain't never been through it.
Person is, two of, living at the same address, the person who's getting the ex parte action against them is removed from the premises.
So yes, during a criminal process, there's two things. There's a civil process of an ex parte protective order in which the court in the first, they issue a temporary protective order in which the individuals need to be removed from their residence in that location because of a stay away order essentially. There's that part, but then there's also the criminal component. The criminal charges are taken out. That's what this bill addresses. During a bail review proceeding or during a pre-trial proceeding, a court can issue, or the court commissioner can also issue a stay away order where the defendant would then have to stay away from that residence as well.
So you're saying the stay away order would be issued, but then the question is whether or not it's going to be a warrant for arrest or whether it's permission.
That is correct. That is what.
He asking for a friend.
Thank you so very much.
Thank you.
Thank you. And before I go to other members, I have a question, for Mr. State's Attorney. You mentioned in your testimony, and I know about the articles of the subcommittee last year. So my question is, why not start where they left off? This looks the same as it was presented last year in the beginning. There were several meetings, it took a long time to get there, so it looks like we're starting from scratching here.
Yes, well, a couple of things. First of all, I apologize, Mr. Dickman is in charge of juvenile, he's in charge of district court, so that's my fault. But that's a great question. One of the reasons, it's very confusing. When you go back and kind of look at the bill, it's kind of confusing, but when you actually look at the statute within itself, it was a lot easier to say, hey, what we want to accomplish, the law already does in these three categories. If you are a first responder, such as a police officer or a school teacher, then you have to look at this within 72 hours. The state's attorney's office must make a decision. That's really what we want. Now, I think the other question is, what do we do in reference to some domestic violence issues? I think now we can go ahead, start fresh, start new. So basically you have answered about the questions about 75% of the groups. Now it's the last 25%. And I think we can have that dialogue to figure out how can we meet within the subcommittee, focusing on that one issue as opposed to multiple issues.
Okay, thank you. I'm gonna continue on this vein, and now go all the way around. Okay, Delegate Lowe's.
Thank you, Madam Chair, and first, thank you, Delegate Addison, for bringing this bill back. I know we've had conversations offline about a situation that my cousin had faced, very similar, where his now ex-wife, at that time they were separated, filed charges against him, falsely accusing him of domestic violence. And, you know, he was later obviously exonerated of those charges, but of course, after having paid $15,000 in lawyer fees to get to that point. That being said, you know, I don't know if you mentioned this in your testimony, I apologize if I missed it. The Attorney
That's
General's
what I'm
office
saying.
raised a concern
Speak to
about
him.
looking into putting to address that. Concerned about increasing those incarceration penalties, you know, might not necessarily for these types of actions, but I think we need to do something. I know the system's not perfect, and I know that there are other, I think it was mentioned earlier, other organizations that have concerns about this legislation, rightfully so, and I know you had mentioned there's possible amendments to address those concerns, so. Yes,
So at first the penalties were 3 years, so we increased them and we made them from 6 months up to 1 year.
okay,
We will find it in the,
okay,
so it probably has to be an amendment.
okay. All right. Well, I'll look for the amendment, but thank you again for bringing the bill back. And I don't, Mr. State's Attorney, did you want to add anything?
Delegate was, spot
Okay, all right, thank you.
Okay, Delegate Moreno.
Yes, in light of well-documented patterns of undercharging and declining prosecuted sexual assault and domestic violence cases, even when there's later review that's identified serious investigative and prosecutorial failures, how does HB 336 ensure that survivors will have a meaningful, independent path to safety and justice if law enforcement or prosecutors refuse to act? Is there?
I'll go ahead and answer that. I think one of the things you look at is those cases, regardless, eventually make it to the desk of the prosecutors. But what we're saying is these cases now make it to our desk a lot more quickly. Sometimes you don't prosecute cases because you don't have the evidence to do it for a number of reasons. However, if an individual, if a victim comes, makes this request a little more quicker, then sometimes we're able to try to get whatever evidence we may need. We may be able to say, hey, we need a police officer to go do A, B, C, or D. I do think this bill would help because it allows us to find that balance of making sure we protect the victims. We always have to make sure from a prosecutor's standpoint to protect the victims, but we also have to have cases to ensure that individuals who have been charged or accused that they're protected as well. We're trying to make that fine line where we're treating everybody the proper way. But say an individual who may have been sexually assaulted goes, makes out their warrant and everything, and say this individual potentially could even be arrested. But by the time it gets to our desk as a prosecutor, whatever evidence we may have needed will probably be gone. Or if you needed a kid or, you know, any bruise, anything like that, you don't need to go to see the nurse. That's one of the reasons I do think that this bill will help us as prosecutors. And the other thing, if prosecutors aren't prosecuting these cases, then we will be voted out. And I do understand that. And so I think from our standpoint, it highlights those types of cases for us, makes us pay a greater attention to those that are there. But also, it makes sense and allows us to protect those individuals that aren't just being drugged through the system because they're being penalized because of the issue of abuse.
Thank you.
Delegate Holmes.
Thank you, Madam Chair. I'll just ask you a question. One of my first cases was a nightmare, all right? And the person had significant mental health issues, and they tried to get an injunction or whatever, peace order, and then they tried to go to the commissioner, and that didn't work, and then they went to the psychiatrist, and that didn't work. The bottom line, it ended up there was a hostage taking incident. Now, nobody was hurt, which is really good, but the task force was there to shoot him up. Okay. So my question is sometimes you're going to have a situation which is going to just happen like split second. And my concern is 72 hours may be too late for, the review the request for help from a commissioner. And so what I would suggest is if you've got somebody, like one of your lawyers that has some experience in the real world, that they can turn it around a lot quicker. Because if you're dealing with somebody like that with borderline personality, they can turn right, left, up, down, be insane, seem crazy, all over the place. And you can end up with a bad situation, or you can end up with somebody killing someone, because there are, psychotic people. So the bottom line is I don't have a problem with this bill, but you gotta do better than 72 hours, and I know that's asking a lot, but, you know, the commissioners are 24 hours, and so I think you need to have somebody that really has a good background in dealing with people, and also maybe even a sociology or psychology degree as well as a law degree to kind of filter this stuff out when they're brought presented. The other thing I would ask is that, I'll make it real quick.
I just want to make sure they can answer
Okay.
the 72 hours question first.
If I may, I think there's a common misconception that when you go to the commissioner's office and you request a warrant, it's issued and it's served immediately. That is not what happens. In all practicality and in all reality, you go to the commissioner's office, a warrant is issued, and it gets served whenever the task force or the sheriff's department or anyone has time to serve it. It's always emergency. So that is a common misconception. That's an immediate protective order, a temporary protective order, an immediate order to vacate the home. There's not someone standing at the commissioner's office waiting and willing to go serve that warrant immediately. So that is an instance when you have emergencies such as that, you call the police, you get them involved immediately, they can go and serve that warrant. It's not immediate at the commissioner's office. So that I think there is that common misconception with regard to the timeline. With regard to 72 hours, I'll certainly let Mr. Bates speak on that, but we do want someone with legal experience laying eyes on that quickly. And OPD is in support of that because they have the legal experience, they have the training, they know if these are viable issues with regard to the commissioner not having that specialized training. So we are in support of a shorter timeline for review, but we don't want it to be a rubber stamp process because that's the problem now is if you don't have somebody who has that experience or that legal knowledge or is trained as a police officer, we don't want it to become a process where it says, yep, issue a warrant, yes, issue a warrant, and it's not a meaningful review.
But the point is, sometimes you won't know if it's a really critical situation or not because of how the presentation is. That's where I'm kind of coming from, and the fact that if a lot of folks missed something needed to happen. Now, the other question is, what if somebody comes in and they have obviously the side of their face looks like a grapefruit, and they say that, you know, that they were hit by and they had to have stitches inside. Now, that commissioner, according to this bill, can't issue a warrant, but yet a warrant is really warranted there because there is a physical injury. So would that be an exception, or if somebody came in and, you know, they had their face all back?
The same system that they uphold.
I think that would either be able to be a quick turnaround, or the commissioner would have authority because of what he saw and could document it to get a warrant and to get that warrant sooner rather than later.
No, I definitely understand. I think one of the things we wanted to make sure we were able to do, there are a lot of different jurisdictions in the state of Maryland. Baltimore City is unique. We have 24-hour people. We look at it and deal with it a lot more quickly than some of the other jurisdictions. We wanted to make sure that all the jurisdictions would have the opportunity to have a time period to have an expert look at that. I think, you know, the issue that you presented, I think is something we can definitely discuss and talk about in the subcommittee to try to make sure, okay, if we see this, if we see that, what does this look like? But at the end of the day, the big thing is to have an expert who has dealt with these, seen these issues, really lay eyes, so we don't have any mass arrests. I just want to give you a couple of numbers. In fiscal year 2024, the number of applicants for statement of charges, court commissioners throughout the state were like 54,864. Total number of arrest warrants issued by district court commissioners were 25,752. And so that's such a significant number. When you even look at 25, it's 53,300, and once again, 25,473. So almost 50% when you look at that. You know, there are definitely some that need to be issued right away. We can try to figure out how we look at those particular issues. But without a doubt, I think we're saying this is a problem, how do we fix it? And I do think that we are really close to everybody having, not everybody will be super happy, but understanding where some of these issues are. And if you do go to a commission, you do see these injuries and things like that, you can also go to the police with those types of injuries. The police can see that. Maybe we sit down and say, if an individual presents themselves those type of injuries, the commissioner now must call the police. Maybe something that simple in putting that in the bill. I don't necessarily know, but I do think in the subcommittee, we're going to have those types of conversations.
Thank you, Madam Chair.
Great. So let's hear from the subcommittee chair, criminal law, Dr. Phillips.
Thank you, Madam Chair, and thank you to the panel. Many of the questions have been asked, but I wanted to dig in a little bit more because I was not a part of the work group. And so in those discussions, Mr. State's Attorney, you say, hey, we can come back and we can work on that 25%. What are some of the recommendations that came out of that you could share with us today?
I think
Particularly to deal with the issue of urgency that Delegate McCombs just talked about.
I think the big aspect was how do we get to the point that we can see as quickly as possible this type of information into the prosecutor's office. And so really what you see is once you look at the statute and it has those three groups, so we've kind of taken what was said and we just worded it a little different. To me, it's a lot more clear. The big issue was on the domestic violence side. The domestic violence side, if I'm not mistaken, it would be within a 24, 48-hour period that if an individual presented themselves, that an individual, even if there was an arrest warrant, that the state's attorney must, within 24 hours or 48 hours, make a determination. That was one of the things I do know we definitely discussed within that work group. And that was, how do we do this, how do we go there? But also, I think one of the things, if I'm not mistaken, we also talked about was the penalty for individuals who are misusing this as well. Baltimore City, the individual, I guess, didn't get a chance to go to the concert, charged against T.I. and his wife. He goes to board a plane in Atlanta, gets arrested. And so that person that took out those charges, nothing happened to them. And so making sure how do you find that balance, because once again, you definitely want to protect the victims, but how do we find that niche within it? And that was one of the issues. I know we've gone back and forth and talked about that particular issue. How do we get to where we need to get to? I just think that if everybody can sit down and everybody talk about their concerns, that I think we can find a way to make it work. But I think the big problem that we're seeing is that the system is just being misused and so many individuals are being incarcerated and charged for no reason and it ruins lives.
Madam Chair, if I could follow up. You mentioned about 50% of the complaints with commissioners end up in arrest warrant.
Yes, sir.
How many of those, if you know the number, end up in any type of conviction as a follow-up?
It's very few, to be honest. One of the things that we looked at, and it's a struggle, and I see delegate as well from Baltimore City who would understand the domestic violence court cases that we have in Baltimore City, especially, is troubling sometimes. Because we may have almost 80% of those cases sometime no process. And so it's very, very difficult as you there are no process for a various number of reasons. Could be someone's like, oh, I didn't mean to do it. Could be like, now they just don't want to proceed for a number of reasons. But one of the things is, how do we make sure that we protect those victims? And, are every person who's taking a charge out against an individual, are they lying? No, not at all. There are a number of victims. And one of the things we want to do, if we can see them and talk and try to understand, have a better understanding of which ones are the victims and which ones are misusing the system. It is a pretty high rate. It's been something that's always been there, unfortunately, even when I wasn't made. For those who don't know, I was a criminal defense attorney for almost 20 years. So I've seen it from both sides. And so it's even being misused back then when I had a number of clients who were incarcerated and locked up just because someone went down there. And then later on, they never showed up, but then they were in jail for 35, 40 days, and now no problems.
And because I've done some work in this area, I've seen it happen as well. My last question really relates to this idea of the arrest warrant being issued and then the state's attorney taking a look at it. Are you suggesting that the state's attorney would have the opportunity to withdraw the arrest warrant?
I think that's something we discussed. I think that if the state's attorney finds that charges have been lodged against an individual, it should not. The state's attorney has an obligation to do everything it can as quickly as it can to ensure those charges are dismissed. And if that individual's incarcerated, do everything they can to get them out of jail as quickly as possible.
And are there times that maybe an arrest warrant may not be warranted, but still a summons and an appearance to respond to the allegations?
Without a doubt, with arrest warrant, you want to say, is an individual a threat to the alleged, to the victim, alleged victim? Are they a threat to public safety? Are they a flight risk? The same things we look at in reference to bail. And not everybody's going to necessarily need an arrest warrant, but sometimes how do we protect this individual? Sending us summons, what does the summons do? And you know, counsel here is right. Sometimes it takes 3, 4, sometimes it takes a week, 2 weeks before they hunt down an individual to serve that arrest warrant. They don't happen right away. And so those are things that are also concerning as well. How do you find that balance? And once again, I do think having a conversation will, subcommittee will help.
Thank you.
Delegate Valentine? I'm sorry, Delegate Henry first, and then Delegate. That's why I had his name there, but keep going.
Okay, well, thank you. Thank you very much, and I very much appreciate the purpose of this bill, but I just have 2 questions. One is actually, or one is a, sort of isn't that so, but the data in our fiscal note, which comes from the courts, the arrest warrant numbers, all arrest warrants issued, as I understand it, including these arrest warrants. So 25,000
No, okay,
is everything.
yes. Okay,
and
I'm sorry, I
it
misread.
actually